Good morning, everyone. We are assembled back Saturday morning, beautiful Saturday morning, another beautiful Saturday morning in Southwest Washington. We have two items this morning, and hopefully we can move quickly through the first and get to the second. We have first up, open meeting provisions of the WSBA bylaws that General Counsel Shanklin will be leading a discussion, and then followed by the diversity committee report that we had to rearrange from yesterday due to some illnesses. So with that, I will turn it over to, we don't have to do a roll call or anything. Okay. All right, we'll turn it over to General Counsel Shanklin.
Thanks. Good morning. So yes, this should be quick. Let me just say that these slides are not intended to be exhaustive. Many of them do not contain the exact language of the bylaws. This is just to familiarize you with what the open meeting provisions are. And at the bottom of the slides, it lists the articles where you can find the information. One of the things I think you'll find interesting is that the information about each topic isn't necessarily found in one location. So I was hoping that that would be helpful. My hope is that you will this is a first pass through it. And then if you have questions, you can ask me, you can ask Tara, and we will continue to learn about it together. Tara, next slide. So the open meetings policy in the WSBA bylaws, like what does it mean? Open meetings are open with no specific definition. I'm assuming that means sort of in a place where people can find it and people are aware of it. Public may attend. The meeting schedules are reasonably available. Members of the public are not required as a condition of attendance to provide their name or other information. That, of course, does not mean that we can't keep lists of speakers. It just means that people are not required to provide information in order to attend. And the general rule is no secret ballot votes. Board elections are exceptions. There's also a couple of provisions in the bylaws that allow voting by email in very limited circumstances. And there are instructions for records retention, et cetera, about how you can make an email vote not be a secret ballot. I didn't include that here because it's not a general thing. Next slide. So, what is the scope of meeting requirements? So this is essentially the definition of action in the bylaws. And so the open meetings provisions apply to meetings, and we'll get to the definition of meetings in just a moment. So it applies to meetings, hearings, actions, gathering of information, and gathering of member comment. That is very broad. Next slide. So which meetings does it apply to? So it applies to all the entities working under the authority of the bar pursuant to court rule, the bylaws, or entities administered by the bar pursuant to court rules. So that would be GR 12.3, the court created boards. The bylaws say the open meetings policy does not apply to this list: the awards committee, the BOG personnel committee, executive sessions, the judicial recommendations committee, and then any kind of a matter that's made confidential by a regulatory or other court rule. Next slide. So as you know, the BOG and BOG committees are authorized to have executive sessions. And this slide in particular is not the actual wording from the bylaws. I started it out that way, but Tara pointed out to me that putting that many words on the slide made it essentially worthless. So these are the six, this is a summary of the 6 reasons when the BOG is authorized to meet in executive session, and also BOG committees. I don't think we need to go through each one, but if you are concerned or have a question, you can check that place in the bylaws. Next slide. Who attends a BOG executive session? The bylaws say, of course, the board members attend, the executive director attends, the general counsel attends, and other persons authorized by the BOG attend. Next slide. There's a specific separate provision for when other bar entities, so not the BOG and not BOG committees, are authorized to have executive sessions. And essentially it's a more limited list. And also, as you can see, it's limited to the scope of their work, so that it makes it's limited to their work. Next slide.
Julie, before you go to the next slide, if you can go back for a minute. So when they're talking about the chair, we mean whoever the chair is of that entity?
Correct.
Okay.
Yes. Okay. Now, what is a meeting? So I love it when definitions use the thing they're trying to decide. A meeting is a meeting. Hello. A meeting is any regular or special meeting of the BOG or other bar entity contemplating transacting official business of the bar, including, but not limited to. And so this list is a combination of action and final action, because those are the words that they use in the bylaws. But instead of just using those words undefined, I just put in the definition. So there are a couple things about this definition. So as you probably know, and I think I have a slide about, there are actually 3 types of BOG meetings: regular, special, and emergency. Why emergency isn't in here, I don't know. I would assume it actually applies to it too. It just, the word isn't in there. But as you can see, it's very broad, but it is limited to when the BOG or bar entity meets contemplating transacting the official business of the bar. Undefined term, again. So, there are some gray areas and room for discussion in here. And before we move off of this slide, I don't think I have a slide, but also in the bylaws, there is a statement that it's not a violation of the bylaws for a majority of members of a bar entity to travel together or gather for purposes other than a meeting or special meeting, as these terms are used in the bylaws, provided that they take no final action as defined in the bylaws. And final action is defined, it's the first bullet here: collective positive or negative consensus or an actual vote. So just to clarify that there are other things that the board is authorized to do in the bylaws that appear to be separate from a meeting.
Julie, before you go on.
Yep.
So would it be a correct conclusion to say that the default is always to have the meetings open?
Yes, I think that the purpose of having the open meeting policy in the bylaws is as much transparency as possible while complying with, the reasons why you'd have an executive session and other court rules. Next slide. Quorum. This one sometimes is a little bit prickly. But here we go. The definition of quorum is the presence of a majority of the entity's voting members. A majority, it specifically says, is more than half. And in addition, the bylaws say a quorum must be present when votes are taken. So we interpret this to mean you have to have a quorum to start a meeting, because otherwise you don't have a meeting. So you need a quorum when you start, and then when votes are taken. And again, as we know, final action is voting and a positive or negative consensus. So just because it doesn't say consensus here, I would assume that it actually is there too. I think where it says votes in my head, I'm thinking final action. Next slide. So there are a lot of different meeting notice requirements in the bylaws. And so I just tried to put them all in a table so that you could see even the content of the notices isn't necessarily the same. You'll note that regular BOG meetings have to, at least the date, time, and location has to be noticed 45 days prior to the meeting. I think that's why you set your meetings for a year, and then that calendar is put on the website so that everyone can arrange their schedules when needed. And then the bylaws specifically say the agenda is posted when it's finalized. Special meeting.
Julie, can I ask a question before you move on that?
Yes.
So I just am curious about, like, for example, we'll take this meeting itself. When we move something from a Saturday to a Friday or a Thursday, does that play with any issues regarding notice? If the public was told we were going to take up an issue Saturday afternoon and we move it to Friday afternoon?
So probably not, because the date that the meeting starts is Friday. It's just continued into Saturday. So, there's nothing in the bylaws that say that once you post the agenda, you have to take things in that order. So yeah, you're right that it is a little bit difficult for people, because they would have to sort of attend the whole meeting if they wanted to make sure that they were able to see the item that they intended to see. But no, I don't think it's a violation. As you have had recent experience with, the 5-day prior notice on special meetings can be waived by unanimous consent of the board. And the same is true for BOG executive committee meetings, that there's a 5-day notice provision and it can be waived. Next slide. So there's a couple of just definitions, sort of housekeeping definitions that go with the notices. Days or calendar days, dates falling on Saturdays, Sundays, or holidays refer to the next business days. And it also notes that WSBA holidays may be different from legal holidays defined in statute. How does one waive the notice? If you're talking about special meetings, if you'll recall, there was a written unanimous consent document that was signed by all of the board. And that is how that one is done. It's not specified exactly how it would happen for executive committee meetings. Does that answer your question?
So it has to be waived when the meeting is set. That's what you're saying?
Well, so yes, the meeting can't be held in less than 5 days for a special meeting after the notice is provided, unless there is unanimous written consent of the board. So the way we interpreted that was we provided the notice 5 days as early as we could. I think it actually was less than 5 days. Before the meeting was held, we were able to receive unanimous written consent so the meeting could go forward. If we had not received unanimous written consent from the board, the meeting would have to be canceled or held, after the 5-day notice period.
So I want to make sure I'm understanding clearly, and that's unanimous of everyone who is still a member of the board.
Correct.
So like if we wanted to have a special meeting on Monday, we wouldn't be able to do it because we don't have all of our board members that could sign a written agreement. We would not be able to comply with that. So am I just understanding? I mean, like we've been basically one board member completely absent for 8 months. So we couldn't have ever waived notice unless we got that one board member to sign on something, correct?
Right.
Yes.
No. Because in the
Yes.
last situation, we reached out to that board member and got her written consent.
No, but that's what I'm saying. But if they did not sign, that they are still part of it, even though they're still part of the board, they would have to be part of that signed. That's
Yeah.
I'm just.
But you can just email them and get the written consent. That's what we did in that situation.
No, but I'm just wanting to make sure that this is different than quorum, that once a half of the majority is there. It really is the full board.
Full board.
Okay.
Yeah, the language in the bylaws is unanimous consent of the board. So yes, everyone.
Sorry, one more clarification, Julie. So if we happen to get the entire board together at a meeting, could they also provide that consent at the start of the meeting?
I think they could, so long as the consent was provided before any action was taken, right?
Yeah.
Before the meeting was convened. Yes.
Thank you.
Next slide. Meeting locations. It's not really locations, but meetings can be held in 3 ways: in person, by video conference, or by phone. Meetings most of the time cannot be held by email. There's a couple of exceptions, both for the BOG Legislative Committee and section executive committees, where they are required to meet on a very expedited basis during the legislative session. And both of the provisions allow it unless a member of the committee objects, and then it's not permitted. I included the section executive committees here because I thought it was important, but I did not generally include all of the other rules that might apply to section executive committees. But just saying, I think knowing that they do also have this email exception is important. Next slide. So Robert's Rules, the most current edition of Robert's Rules of Order, governs proceedings at BOG meetings. This sometimes comes up because there's a lot of other information in Robert's Rules of Order that is perhaps instructive, perhaps interesting. Governor Stevenson and I have been working on a document that we're hoping will provide the board with kind of an analytical framework for what to do when the bylaws are silent or might be conflicting or unclear. And part of what we've referred to as Robert's Rules, but that's not a requirement. We are required, you are required to use Robert's Rules, to govern the proceedings at BOG meetings. And it literally says BOG meetings. It doesn't say any other meetings, just BOG meetings. Next slide. So I wanted to just make clear, like, what is final action? What does that mean? Just so you know when you're doing that. And we sort of already touched on this. It's a collective positive or negative consensus or a vote of the voting members present at the time of the vote. And it literally says in the bylaws, upon a motion, proposal, resolution, or order. So it allows presence to be in person or electronic, which for meetings, electronic is limited to video conference or telephone. In other circumstances, the word electronic is broader, but specifically it's limited for meetings. And the bylaws say that consensus governs in BOG committees. They should vote only if they cannot reach consensus. Next slide. Yeah. So the general rule, as we saw earlier, is that there aren't secret ballot votes in public meetings. There are a few exceptions: the elections that are conducted by the BOG and votes to remove governors. I have no experience with those, but they are listed in the bylaws. Next slide. So who votes? The president only votes, it says, when the president's vote affects the result. The president-elect is not a voting member of the board. The president-elect votes only when the president-elect would be acting in the president's place at a board meeting, when that vote will affect the result. And the same is true for the immediate past president. I did not include the treasurer here because the treasurer is required to be a member of the board and is therefore a voting member of the board.
Julie?
Yes.
Yeah, so just a question about the first part that says president only votes when the vote affect the result. The way I interpret that is, the way we're usually using that is when there is a tie. But the way I actually interpret that is that could also mean that the president can make a tie because it affects the result.
That's an interesting interpretation that I would actually have to look at. So Yeah,
In that
I don't-
instance, so if you had a tie,
Mhm.
I mean, so in that instance, if the president made a tie, that's actually then a result where the action is defeated because it's neither yes or no.
Right.
It's neither yes or no. But anyway.
Governor Williams-Ruth had something to add to that.
Oh, I'm sorry.
No, I will defer to the parliamentarian because he's saying the things. If the president wants it to fail and it was passing by one, you can make it as a tie. It'll then fail. If you want it to pass and there's a tie, you vote and you're the one that breaks it up to. So I agree with the parliamentarian.
But under that scenario, the president would have 2 votes. That doesn't make sense to me.
No, because as the
No, the
parliamentarian was
president
just
does not have
explaining
2
that
votes.
a tie is a defeated. So if you wanted something to fail and it was a 5-5 tie, you choose not to vote, it will fail.
Oh, I see.
If it was 5-6 and it was presently passing and you wanted it to fail, you make it 6-6. It's a tie vote, it will fail. So as the parliamentarian was explaining, that is the way you can impact either if you want it to pass or if you want it to fail within the 1 vote margin.
I wonder why the president, if they wanted it to fail, they just would vote for it to fail.
Yeah, but again, you only get to vote if it's in a case of 6 in favor, 5 against. You can be the 6th vote in against. It then becomes a 6-6 tie.
And a tie then defeats it.
So
then the tie fails.
Yeah, I've never heard of that before.
right,
So
that's not been the way, in my understanding, that the board has interpreted this, but I think it merits looking into and getting a deeper understanding of when exactly the president can vote.
for the record, I would never do that.
And that's
Executive Director Nevin.
Julie, I have a question. So I believe that sort of the order of succession, if the president isn't available and the president-elect isn't available, next up is the treasurer.
That's
Immediate
true.
past president is last. So I am curious when the treasurer, I know you're not even, no, you are, if the treasurer is not able to either. So if the treasurer is sitting as president presiding over the meeting, then do they only vote when the vote will affect the result, or do they still retain their vote?
So my answer to that would be if they are acting as president at that meeting, then they only vote if their vote affects the result. Again, the bylaws are not entirely clear. And that's why I think this analysis that we're working on will help the board to go through and try to make sure that the bylaws are interpreted in the way that they were intended and that they're consistent. But, if the treasurer were acting as president and could vote because that person is a board member and then vote again as president, that gives one board member 2 votes. And so that doesn't make sense to me.
No, they wouldn't have 2 votes, but I think the issue is in that instance a question of the treasurer presiding. I don't know that they lose their opportunity to vote. They lose the opportunity to affect the result because they already have a vote. But anyway, you and I need to work on that to clarify.
General Counsel Shanklin, you might also add the Shickety asterisk to the voting as a member of the Board of Governors and President-elect, where we discussed during my term that perhaps it would be inappropriate to vote as a governor and then break the tie in the unlikely event that the president is not at the meeting and the president-elect is a voting member.
Right, which is exactly, I think, consistent with what I just said about the treasurer when the treasurer is acting as president. But yeah, there's nothing in the bylaws at all, positive, negative. It's completely silent about governors serving as both governors and president-elect. That's why I didn't include it here, because there isn't anything in the bylaws about that.
And some troublesome governors have done that. Governor-elect Adewale.
If we look at the intent of this, it is the occupant of these offices, the president-elect, the immediate past president, when they are the manager of the meeting. In other words, the idea is if you are managing the meeting, you should be above the fray. And you should only come in when there is a need for you to impact the results. In other words, when there is the intent is clear. If the treasurer is acting in these offices, he loses that opportunity to be able to continue to be a virulent advocacy as a member for an issue that he's interested in. The intent of this procedure is to take the presiding officer of the BOG above the back and forth between the two sides, and to only impart the result when it's absolutely necessary. So if we get to that point where we said, you can exercise your power as a treasurer, as a member voting, and then you get to also preside over the meeting, then we lose the ability, the impartial ability of the manager of the meeting to be above the fray. I think that's the intent, and we need to kind of abide by that.
Governor Stevens.
No, I appreciate Governor-elect Adewale's comments, and I think, like I said, Julie, I think you and I have some work to do to actually clarify that and really place that in front of you, which is what happens when somebody otherwise has a vote, but now they're in the position of, as you say, Governor-elect, managing the meeting. And so.
Any more questions about that?
Governor Williams-Ruth.
I'll simply say that, again, I posted straight from robertsrules.com the actual frequently asked question number 1, and what Governor-elect Adewale said is actually part of the part I didn't copy and paste, but that's exactly what is on the website regarding, if it is a person who has, and they use the example of a smaller committee. If you have the right to vote, you still do. But if you're running the meeting, it's right there in frequently asked question number 1. Is it true that the president can vote only to break a tie? So I would encourage everyone to look at the rules as well as our bylaws.
Okay. Next slide is voting on BOG committees. Again, there's a general rule and an exception. The general rule is that only governors vote on standing BOG committees. There are at least 2 exceptions. One is the BOG Legislative Committee, where the president-elect, and immediate past president are all voting members. And the BOG Executive Committee, the president and the president-elect are voting members. As we discussed yesterday, the diversity committee, the current diversity committee, is a combination of a BOG committee and a WSBA committee that were combined, I think, in 2012. And then the bylaws were never sort of caught up to that. So potentially that is another exception, but again, it's not, the bylaws don't say anything else about that situation. Minutes. So the bylaws require minutes for BOG meetings, except in executive sessions. They're not required there. Committees and other bar entities are also required to keep minutes, except for authorized executive sessions and the sub-entities. So the subcommittees, et cetera, are not required to keep minutes unless they have authority to take action, which I don't think most of our sub-entities do. Sections are required to keep minutes. Section executive committees are required to keep minutes. And I think the last slide is what the heck goes in minutes. And this again is subject to a lot of interpretation. The bylaws specifically say minutes should contain the people who attended, the members who attended, the date and time of the meeting agenda, which is interesting. I don't know if you just attach it or if you just list the items. I think probably the meeting agenda gets included because you use it as the topics as you go through your minutes. Any final actions taken, so votes or consensus final actions. And then of course, the one that is the subject of the most interpretation is reasonable summary of discussions. So that is the end of my presentation. And again, what I hoped by doing that and putting the bylaw citations at the bottom was to generate discussions. Please ask questions. I think this is great. And I'm sort of hoping in the future that we can almost develop something that looks like kind of a comment to the bylaws so that you are all clear about how the bylaws are currently interpreted so that you can ask questions when you disagree with it, and we can have reasonable discussions about how the open meetings provisions of the bylaws should be interpreted.
Thanks, Julie. If folks have questions, we can entertain one or two, but we do have guests that are ready for our next presentation. So if anybody has a question, I'd ask you to be brief. Ms. Hawkins, please be brief.
At least Julie and Kyle, you probably have noticed what I want to talk about. So I do have some disagreements with some of Julie's slides, and to follow up on a comment I made yesterday. I think that someone asked the question that the presumption is in favor of open meetings, public meetings. And that is what I believe is the policy of these bylaws. And I think that the board needs to follow that policy. There was a meeting held on Thursday. It was held, I believe, in violation of the bylaws. There is no provision in the bylaws for a retreat, let alone a retreat that has sessions that are not public, whose subject is not announced, where there is no opportunity for the members. Personally, I hate the phrase public because, as a liaison of a section and as a member of the bar, I'm not really a member of the public. But the meeting on Thursday is either a board meeting or a special meeting or an executive session. If it is a board meeting, it's to be public. If it was a special meeting, it needed to have notice. I believe the 5-day notice waiver applies to the number of days of notice, because the very next sentence of the bylaw is the special meeting will only consider such matters as set forth in the notice of the meeting. That sentence is not consistent with saying you can waive the substantive part of the notice. So, to this day, whatever happened on Thursday isn't public. What was discussed or how long or whatever. I think that is wrong. I think it's a violation of the bylaws. And I don't think the bylaws should be cleaned up to allow more secret meetings. I think what should happen is that they shouldn't take place. I also disagree, and I've had email exchanges with general counsel about this, but I don't believe that it is accurate to say that the only meetings that have to be public are meetings in which final action is taking place. The bylaws instead state that it has a definition of action. And action means transacting the business, including but not limited to member information, deliberations, discussions, considerations, reviews, evaluations, and final actions. Final actions is only one thing that could be considered action, but there are many other things, including discussion. I assume there was discussion on Thursday. I assume there was information. I assume there were deliberations, but whatever, it falls within this definition and should have been considered public. We have some very limited exceptions to public meetings. Those are spelled out, legislative, lawsuits. And I think the policy of the Board of Governors should be that those definitions are read very narrowly. Because the truth of the matter is, if you're having a meeting that's 2, 3, 4 hours long, it probably is important, and it probably means that it's important for the members of the bar to know about. So the meeting on Thursday is either a Board of Governors meeting, it's public, a special meeting, which I've already talked about, or an executive session. Executive session is also defined and includes a specific provision that the president will publicly announce the purpose for meeting in executive session and the time when the executive session will be concluded. And as you know, then you get that extensions. So if the meeting was supposed to be an executive session, there should have been the BOG meeting brought to order. It was announced it would go into executive session. It was in the agenda and in the announcement what the topic was. It should have adjourned or been extended. The slide that has 4 possible items on it: regular BOG, special BOG, emergency BOG, or BOG Executive Committee meeting. The meeting Thursday is none of those 4. So whether it's about Thursday or any other meeting, ever since we need to be sure that executive sessions are minimal and infrequent. They shouldn't be happening every day of a Board of Governors meeting. Not if you don't want there to be a lot more members of the Bar Association wanting changes that eliminate executive sessions altogether or make things even more strict. Everything here should be public. Now, there was a lawsuit. We were released from the law on open public meetings, but we're not released from our bylaws. So I certainly hope that whatever's happened this week, whatever's happened in executive session recently, that pattern of more and more and more things happening in executive session or secret altogether. Because remember Thursday's meeting, no publicity about what it was about, no notice, that doesn't happen anymore.
Thank you, Ms. Hawkins. And we do have guests that we need to get to, but I'm going to give equal time to President-elect Thompson to respond. So President-elect Thompson.
I think Governor Clark wants to respond possibly too. So just briefly, Nancy got an email from me way back on July 8th outlining what was going to happen. Told her that the retreat consisted of a confidential facilitated board training session and a public discussion relating to the future of the law and the courts, including legal regulation and the delivery of legal services. The Bar Association did post the retreat agenda for the public session. And I think the executive director and Ms. Hawkins had a telephone conference about all this too. We've had trainings involving diversity, equity, and inclusion. I don't think our members or the public have been allowed to attend those, nor do I think they've been given notice of them. So if we're not going to have any more diversity, equity, and inclusion trainings with just the members of the board, so maybe we should invite our entire membership and the entire public to attend all of those future diversity, equity, and inclusion trainings, as well as maybe if there's a recording of the past trainings, we can have the public and the members look at those too. But if we can't have any kind of training sessions that just involve board members, and possibly a future training where we were talking about having a facilitated discussion between the executive management team and the board, then there's not going to be a possible safe space. There's not going to be a possible time when trust can be built. Just as simple as that. If you don't want a tribe to build trust, to mend fences, to have a candid discussion about things, then happy to have nothing but public open sessions where everybody can listen in and be present all the time. Glad to do it. Won't help mend fences.
So I'm going to turn to Governor Clark and Governor Williams-Ruth. If you've got a brief statement, Governor Clark. Sure. So we'll recognize just those two, and then we'll move on to our next item. So Governor Clark.
So to echo what he just said, there was no action taken. There wasn't a minutes because we didn't do any BOG function as far as governance. Trainings are not a meeting. They're not executive session. And okay, respectfully, I don't, okay, you're wrong, Nancy. I'm sorry, but that's my take, is your legal, okay. I mean, there are trainings that are allowed by government that are not, I mean, so, yeah.
Thank you, Governor Clark. Governor Williams-Ruth.
Thank you. And I'll slightly disagree in the context because I was just looking at the municipal, let's see, and of course, now it says the Municipal Research and Services Center is a nonprofit organization that helps local governments across Washington state better serve their communities. They have a specific thing about open public meetings, which again, we're not part of, but it does address retreats. And I'll simply say that yes, a retreat attended by a quorum of the council, again, we're talking about municipalities, where issues of city business are addressed constitutes a meeting. What President-elect Thompson just said is why I believe that we are perfectly in the right for what we have done that has not been public. We did not address BOG or WSBA business. We were building, team building and trust exercises. And I believe that we shall continue to do these things where we are not talking business. So thank you, Mr. President. Again, anyone wants it, mrsc.org is where you can get a little further guidance on those issues.
Thank you, Governor Williams-Ruth. All right, we're going to move to our next item.
Mr. President, sorry, a 10-second comment.
10 seconds.
10 seconds. You can start me now. I just want to say that I agree with the comments by President-elect Thompson. But I also want to say that I appreciate Nancy's comments, and her bigger point is correct. And if she weren't here, we'd have to invent her. So I'm glad we've got people holding our feet to the fire on this. Thank you.
Thank you, Governor Abel.